Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to another episode of Legal Ease, the show that converts legal jargon into legal ease. Now, I'm sure many of you have not missed the recent news on the spread of listeriosis, a very deadly disease it's proved, and the source that they've managed, the Department of Health has managed to trace. A number of victims have already fallen foul to the effects of listeriosis. There's been 118 or more fatalities and about 1,000 more people that have been affected by it. Now, just colloquially, we understood that it's coming from a source of a factory in Mpumalanga, and to help us understand the effect and the origins of listeriosis and what one can do if one has fallen a victim to having consumed some of the foodstuffs. I understand that some of it is chicken, the rest of it is what they would term fast foods. A number of retailers have had to recall the products, but a number of people have already lost businesses due to the fact that their business is dependent on using some of these products. So the fallout is quite immense. Listeriosis is a disease that we didn't hear of in the past, but helping us to understand tonight the effect of the disease and what you could do in respect of compensation and specifically from the legal angle, I'm pleased to welcome tonight Chris Smith, who is a senior associate, but he graduated in 1994 and he took up a position with the Department of Justice in Mpumalanga. So he obtained a B. Juris and an LLB degree. In 1997, he relocated to Cape Town and completed his articles with Van der Maas and Associates in 1998, whereafter he was admitted as an attorney. And Chris joined his present firm, DSC Attorneys, in 2006, and shortly thereafter, he was promoted to associate and to senior associate during 2012. He specializes in personal injury law. He has extensive experience in civil and criminal litigation, as well as family law. In addition to acting on behalf of victims of road accidents against the RAF, also known as the Road Accident Fund, Chris has acted in matters relating to police assaults, unlawful arrest, unlawful detentions, as well as medical malpractice. So you can see that we have a really diverse range of skills in Chris, and you're welcome to call in when the show opens after the first quarter. Chris, welcome.
Thank you very much for having me, Ashraf.
Absolute pleasure. Chris, is there any legal requirements pertaining to microbiological testing in South Africa? Because I understand that's where this whole disease emanates from. The facility was tested. Mm-hmm. And that's because they couldn't find it for a while. I know in Australia, they've now found it in melons. There were 4 fatalities. In the US, there was apples, I think.
That's correct, sir.
So here, we're talking about fresh meat products.
Ashraf, there are regulations in South Africa, and it's mainly regulated by the Foodstuffs, Cosmetics and Disinfectants Act. But there's also the Fresh Meat Act, that has certain regulations that all these producers and manufacturers have to adhere to. Stringent testing, and it is suggested that certain bacteria need to be tested for on a regular basis. Unfortunately, the Listeria bacteria was not one of the specific ones listed. So there is an extensive list that all manufacturers and producers have to adhere to. But like I said, that was unfortunately not one of the regulated bacteria.
So what you're saying is, it was there, but it wasn't on the list, so they didn't specifically test for that.
That is correct, sir. So you'll find that in the market that we're looking at, where the listeriosis has now manifested itself, there are quite a few bacteria that has to be tested for on a specific basis, and that is regulated, like I said, in terms of the Act. But the Act doesn't list each and every bacteria that has to be tested for.
Okay, so if I understand that the manufacturer will go through the list and say E. coli, which is like the more well-known prevalent, he would test for that on a regular basis. This one fell through the cracks. It might not have been on the list.
That is correct, sir. But despite the specific bacteria not being on the list, does not mean that a manufacturer doesn't have to take their own initiative to test for certain bacteria which they might suspect might be a hazard in the production of foodstuffs.
Well, given the historical background, it emanated in the United States and it went to other jurisdictions in the world. Surely one would have expected that should have at least popped up on the list. Like you say, if it's not on the list, just take the precaution.
That is correct. So Listeria and the Listeriosis bacteria is nothing new to South Africa.
Oh, okay.
And as you've mentioned before, right over the world. So even although the public in South Africa has certainly in the past 12 months now become aware of this, the manufacturers and producers must have definitely been aware of, especially Listeria, it being such a deadly disease. So one would expect if you venture into the type of market where you will be dealing with fresh meat products, that you would take the necessary steps to prevent any bacterial infection.
I mean, this is a large corporation. This is a listed company. And from my reading of it, it packs for most, I think, Woolworths has a facility within the facility, but separate. So in the factory, Woolworths has an isolated unit. The other big retailers, I think except Checkers, I think it's Pick n Pay and Spar were purchasers of this product predominantly, including their no-name brands. Am I right?
That is correct. So one just has to be careful when you start naming certain individual food suppliers, because the media has unfortunately just used this blanket explanation of what products could have been contaminated. But like you rightfully pointed out, Woolworths, although they had a facility in the same facility as Tiger Brands, were not using the same product.
Yes.
So it's always obviously important to try and distinguish.
Yes, they haven't had they've had their own, I think, cautious product recall, but it was certainly not the brands that were named as having caused the problems both in chicken and in the Poloni products.
That is correct. So Woolworths did what they call a voluntary recall of certain products just as a safety measure. But as far as I understand, there has not been any link to the Listeria virus in Woolworths foods.
Now, a lot of people have obviously been affected by the disease, and I dare say there might be other people that have not had the benefit of this recall. For example, you might be living in a rural area, you might have stocked up for 6 months. I'm just giving that as a scenario. You might be consuming this. You don't know of the mainstream news about this. The Department of Health hasn't been able to come out. You still might be consuming this in ignorance.
That is correct, sir. And I think, unfortunately, a large part of the community that is affected by this are like the people that you're saying that might be in the rural communities that might not have access to the internet, to daily newspapers, or to a program like we are producing, or that you're producing at the moment. And therein lies a big problem in further infections taking place. Even although recalls have taken place in the major centers, in the major shops, I'm sure there will be certain areas in rural areas where they might not even be aware of this, or not think that it is really that important to comply with the recall.
Now let's just talk about who would be able to institute a claim. If you're a parent of a child, obviously you would have a minor child, you would have the right to claim. What about, because I understand that some of this might have been a stable product in the school environment because it was a cheap source of protein. It was affordable.
That is correct, sir. So there will be different categories of people that will be able to claim. Certainly the parents on behalf of minors that have been affected, that have become ill. Unfortunately, the vast majority of the deaths that occurred as a result of that are also small children, and their parents will, needless to say, have a different type of claim against, in this instance, Tiger Brands.
So what kind of claim would they have? I'm just thinking back to some of the settlements that we heard of today, where Deputy Chief Justice Dikgang Matsneke was acting as an arbitrator in the life matter. And there, over and above the 120,000 offered by the state, there was this new kind of constitutional damages of 1.2 million, what kind of claim will you have against the supplier?
Well, you will still need to quantify your claim, and therefore there are different, what we refer to as heads of damages, but different categories which you would be able to claim for.
Let's try and break that down.
The unfortunate cases where you're dealing with a death, the deceased direct family will certainly have a claim for the emotional shock and trauma suffered. Unfortunately, the awards made in the South African legal system are not that high, because the problem is, of course, quantifying such a claim. It's very difficult to put a price on a death of a child or a spouse or a loved one. So in that instance, the claims are not very high. When you're looking at, for example, the loss of a breadwinner that has been, that has been affected by, the loss of a breadwinner will mean that the dependents of this breadwinner will have a claim for the loss of support.
But that's easier to quantify.
That is easier to quantify.
You say your life, you're expected to work up to the age 65, you're earning 3,000 rands a month, you take that over a period, and that's easier to quantify.
That is correct, sir. That's in addition to the emotional shock and trauma.
Yeah.
And
the emotional shock is difficult, as you point out. I mean, is there like a ceiling for emotional shock?
There isn't a ceiling, but in South African law, these awards have unfortunately not been very high. And when awarding claims in a case like this, the courts will look to see what has been awarded in the past, so that people can be awarded.
So is there a baseline that we can be talking about?
I think it is difficult, but on average, 200,000 rand would be an
so all in
claim
for shock and trauma.
For the shock and trauma and the loss of the
emotional.
Yeah, but in addition to that would be the loss of support, the loss of income that the family or the household is now suffering, and the claim for loss of support will be we'll be able to institute that on behalf of the minors. Okay. In addition to that, further claims that might follow would be the obvious ones. For example, if you affected yourself, your hospital and medical expenses. Yes. And in the past, in other words, up to the date of the case being settled, and also for hospital and medical expenses that might be foreseen in the future.
So it's along the lines of the RAF, basically?
Something similar to that, yes. You will also be able to claim for general damages if you suffered any significant damages, and of course loss of earnings if you were booked off sick, for example. You'd be able to claim for that. But it's important to understand that you still need to quantify that claim. In other words, you will have to tell a court what these losses are, Chris, and how you calculate
we're going to come back to that quantification. Please stay tuned. Time for a short break. Assalamu alaikum wa rahmatullahi wa barakatuh. You are tuned to another episode of Legal Ease, the show that converts legal jargon into legal ease. During the first part of the program, we spoke about listeriosis, its origins, its testing, and the devastation it has wreaked in certain households across the country. We've learned that there should have been testing for this, although it was not a listed disease. But the fact that it was in the public arena for over 12 months ought to have drawn attention to the fact that this thing is something that should have been tested. Now, we know the Department of Health had traced this back to a factory in Mpumalanga, and it's affected bologna products as well as certain chicken products. Chris Smith, as I said earlier on, is a specialist in the area of personal injury, and a man who's extremely experienced about claiming damages and what you can claim. Chris was explaining just before the break about quantification of damages. Chris, can we just go through that again? There are 6 areas of damages that you can claim.
That is correct. So strictly 5, but just to repeat what we've said earlier, if you're dealing with the death of a person,
a breadwinner.
If it was a breadwinner, there would be a possible claim for the minors in regard to the income that is now not being brought into the house anymore. And that is simply quantified by looking at what the income of the deceased was. And that would be calculated for the minors up to 19 and a half or 21, depending on, or even 18, on average 19 and a half, till they would become self-supportive. But additional to that, these minors would also have a claim for the shock and trauma, emotional shock, and the loss of the breadwinner, which in this case would obviously be the parent. The spouses of these deceased might also qualify for a claim for the loss, but like I said, unfortunately, that is not a very big claim. That would be general damages. In addition to that, the second category that we refer to would be for hospital and medical expenses incurred from the date that the infection took place till the date that this matter is settled. And if it's foreseen further medical expenses after settlement, that would be the third category, which we refer to as future hospital and medical expenses. The fourth and the fifth category really refers to loss of earnings. Also in the past, if you were hospitalized during the period, you were not paid for that, you would be able to claim that. And if it's in more serious cases where your doctors might foresee that you will be booked off in the future for treatment, hopefully that won't be necessary. If you can quantify that, you will be able to claim that as well.
Now, on talking about claims, Chris, who do we claim from? I mean, there's so many people in the chain. You bought the product from a store that sells this little quarters. He bought it from the supermarket. The supermarket bought it from the wholesaler. The wholesaler bought it from somebody else. And you go through this entire chain. And I don't even know if the factory bought something that was already contaminated. How do they, what is this disease? Where does it emanate from? Is it from meat or?
Fortunately, due to modern technology, the Department of Health was able to trace the specific strain, the SD6, to the factory in Polokwane and then also the one in Limpopo. If you are proceeding with a claim against in this instance, Tiger Brands, and you are going to make use of a common law claim, you will have to prove specifically where the negligence came from and where the infection took place. But in terms of the Consumer Protection Act, the consumer or the claimant in this instance no longer has to show negligence. So the consumer doesn't have to show where the infection came from, and they would be able to sue anyone in the chain, from the original producer to the manufacturer, the supplier, and the retailer. Of course, rather challenging is going to be to indicate specifically where you got the infection from. But if it's the SD6, like I said, with some pathological evidence, you would be able to link it to this infection that occurred at Tiger Brand.
But isn't part of the evidence that you must actually have the product in your hand?
You won't have to need the product in your hand, but you will have to show the link between the infection.
So what your medical records will have to show that you are suffering from this particular strain.
That is correct. So even although the Consumer Protection Act relieves the burden of proof, you will still need to show where this infection came from. And it's also important to remember that not everybody that has contracted the listeria or listeriosis necessarily got this from the Tiger Brand, the Tiger Brand factory. So if you are going to take on, in this instance, Tiger Brand that we're talking about, you will have to show that it's the same strain of virus. And like I said, that is already been done. But without that proof, it might be very difficult. It might be an uphill battle for you if you don't have the evidence.
Well, here's your opportunity to join the conversation, put questions to our guest. He's very knowledgeable. He'll be able to assist you. If you have workers in your employ, perhaps some of them have been affected by this, if they have children that have been affected. So here's an opportunity for you to join and ask the necessary questions. We've already heard that under the Consumer Protection Act, you don't have to prove negligence, which we will dig into a little bit deeper now. But certainly you're going to have some kind of proof that says that we hold this company liable for the damages suffered, because that's the core of this. Who do you hold liable? I mean, that's, and if you do, you're going to have to prove that, but the burden of proof is on you.
That is correct, sir. And that, like I said, that is where the challenge really lies, is connecting the infection to a specific defendant in this case.
Yeah.
There's been other strains of listeriosis that's now also, or listeria that's also been identified that now that is not directly linked to the enterprise and
Products.
products. So not all of these people will necessarily be able to make use of the information that the Department of Health has now gathered in regard to the SD6.
And what about products imported from outside South Africa, like Brazil and the US? I mean, who would you hold liable there? The importer, the wholesaler, or both?
Once again, if you are going to proceed in terms of the Consumer Protection Act, any of the people, any of the parties to the chain will be, you would be able to hold liable. So if we would have to
Chris,
take
I'll ask you just to pause. Caller, please go ahead.
Assalamu alaikum, Ashraf.
Alaikum salam.
Assalam, and greetings to your guest.
Good evening.
Good evening.
Good evening, Chris. And I see the program is wonderful. What I want to know is, I don't know if it is related to the topic we are discussing here, that we have a lot of hospitals. When patients go in there, they come out with bugs. Now, what is the claim there? What is the situation? Can you somebody say, right, we are going to claim because we went to the hospital and here the patient has picked up with a bug in one of the wards. So what is the situation there? Is a patient or the members of the family, can they go and sue the hospital, or what is the ruling on this? I'll listen on the TV.
All right. Thanks for the question. Chris, you follow what he's saying?
Yes, thank you very much for the question. What you're referring to is slightly different to what we're dealing with in the program tonight. But surely you will be able to proceed with a claim against the hospital. Once again, the burden of proof is squarely on the shoulders of the claimant. And in this instance, the burden of proof will be slightly different. But we have had numerous cases that have been referred to our firm, specifically referring to infections in hospital. One has to understand that hospitals are full of sick people.
Yes.
And there are all sorts of bacteria and infections, possible infections lurking around. And one will still have to show negligence, at least on the part of the hospital, in not preventing further infections. But it is certainly a case that is worthwhile looking at, and like I said, that it's not uncommon. We have heard of that in many instances.
But just to understand that, and just to take the point further, although it's not the topic, we have another caller. Caller, please go ahead.
Thanks, gentlemen. Good evening. Wonderful show. I just want some understanding. In terms of this process, what's been put onto the news, there are two companies, obviously, that have been identified with this claim. The emphasis, however, is only on one company and not on the other one. So when you are filing a suit of this nature, maybe Chris can give us some understanding what are the so-called steps involved for those who would not join any party or legal firm to put the claim forth. Is it possible for them to put the claim forth themselves so that they could get compensation themselves from this process? Audio of the TV.
Okay, thank you for your call. So, Chris?
I'm not sure if the caller is what companies the caller is referring to, but Tiger Brands being the owners of Enterprise and also Rainbow, I think Rainbow, that might be, that was why the focus is on Tiger Brands as the owners.
Yeah.
But I'm sure that when this claim proceeds to court, all of the companies will be listed as defendants in this matter. So it is really not relevant as to against whom one would succeed.
It's time for a short break. We're going to come back to finish that question. Please stay with us and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh. And a reminder that you're tuned to Legal Ease, the show that converts legal jargon into legal ease. And tonight we're covering the outbreak of listeriosis as well as the compensation that one can claim. So far the callers have had two very, very important inputs. The first one was, what could you do in order to claim against a hospital where the patient appears to have picked up a bug in the hospital? And it's a very in-depth topic on its own, but Chris was attempting to answer it. And the second question was, there were two companies that were prominent, but The fact is that there is one holding company, and there are many other companies that might also now be exposed, not just these two. And can you institute the claim on your own? Chris, let's just revisit the first question. It's a difficult thing to prove that you picked up a bug in hospital.
That is correct. So it's not impossible. With modern technology, it is possible to isolate these infections, but besides proving that you picked up an infection in hospital, you also have to show that it was due to negligence that you picked up this, and that might be a bit more of a challenge, but definitely, certainly not impossible to prove. To get back to the second part of the caller's question, as to whether a person would be able to institute this claim on their own, I think that would be a challenge.
Yeah.
One would definitely need to appoint a specialist attorney in the field, basically because the quantifying of the claim would be a challenge, and it could also be very costly.
Yeah.
So you would have to get someone to do that on your behalf.
But isn't that the problem? Because costs scare people away. I know we have the Legal Practices Act, and by August there will be a lot of developments. Attorneys will be and advocates will be classed as lawyers, and you could approach an advocate directly, etc. But what advice would you give to a claimant who's been affected and doesn't have the funds? Okay, could he create a class action suit, or could he, as the caller asked, can he do it on his own? And what mechanisms are there from the legal fraternity to entertain this?
Look, certainly a class action would be the ideal way for a person that may not have suffered huge damages. So in a class action, the group of people all get together to proceed with the claim, and the quantum, the size of the claim is really dependent on how many claimants you have. But when it comes to funding, the mere fact that you're joining a class action doesn't mean that it'll necessarily be funded by someone else. You will still have to enter into an agreement with the legal firm representing you as to how they will be compensated at the end.
So let's just unpack a class action, right? If 20 people get together, those 20 people are the claimants. It doesn't mean the 180 people can benefit from the claim of these 20 people.
No, to enable you to qualify for that, you will have to register as part of the
as
class.
A group, a part of the group.
So you will have to still mandate the firm to represent you in that. As the case is, I'm aware of a class action that is about to be registered against Tiger Brands, but not everybody has decided to join the class action, and some people have decided to proceed with claims on their own for various reasons.
But even those claimants, if legal expenses are extremely expensive, as when legal services are extremely expensive, they could approach your firm, for example, and enter into a contingency fee.
That is correct. So, if we feel that there is merit in the case, we will certainly look at concluding a contingency fee agreement with the claimant. And what that basically will mean is that if we are unsuccessful with the litigation, that the claimant will not pay us.
So it's a win-win.
It's a win-win.
If you win, you get paid. If you lose, you don't get paid.
Commonly referred to as a no-win, no-fee.
No win, no fee, right.
But that will really depend on each individual claim that is being lodged and the merits. The claim would obviously have to be substantial enough to cover the legal fees as well as compensation for the plaintiff.
So there's an interesting little clip there. It shows perhaps a very unhappy claimant who says that he hasn't received enough. I mean, but this doesn't now happen. It used to happen in the past. Contingency fees arrangements have to be registered with the Law Society. There are limits to what you can get out as an attorney. It's 25% of the claim or 100% of your normal costs, whichever is the lesser. So it looks like here the claimant will not be out of pocket. He will not be robbed, if I could put it that way.
No, certainly. I think that was the main objective of the Contingency Fee Agreement Act.
Yes.
The Act stating, as you rightfully pointed out, that a claimant cannot receive less than 75%. It is important to also take into consideration that the Act doesn't make provision for simply taking of 25%.
Sure.
That the maximum fee will not exceed 25%.
Yes.
So at the end of the day, the the lawyers' fees are what they are,
Yes.
as long as it doesn't take up more than 25%.
Exactly.
You mentioned earlier double the amount. The simple way of looking at it, the fee is the fee, or double the fee, but never more than 25%.
Whichever is the lesser, yeah.
Yeah, and that is, of course, the idea behind entering into agreement like that with someone is to grant access to the courts for people that don't have the money to initiate a claim.
But obviously, the advice that we would give is choose your firms carefully. Choose somebody with experience in the area of personal injury or claiming compensation. Like we said earlier on, perhaps RAF, medical negligence, those people that know what documents to put together. It's a massive task to put a claim together.
No, definitely. I would advise anyone considering a claim to approach a specialist firm to give them advice. And many firms like ours will see a client and conduct an initial investigation without charging the clients, and then should we feel that there is enough merits in the matter to then conclude the contingency fee agreement. And like you said earlier, it is then really a win-win scenario.
Well, that's very important because it's a further saving. If you don't pay for that first consultation, you are getting your advice for free. You are absolutely free to take the matter to somebody else or remain with the firm that's giving you the advice. But surely one would think with a claim, with the damages claim of this magnitude, isn't the company that they're going to be suing also put under pressure?
No, most definitely the company that is being sued is being put under pressure. But the contingency fee agreement will protect the claimant
Yes.
from any possible
Yeah.
claim. Look, if you are unsuccessful in your claim, there is always a possibility that the court might award damages or might cause costs against you,
Yeah.
meaning that you will have to pay for the failed attempt
Yeah.
at proceeding. But that is why it's important to get an opinion from a professional, specialized firm before you proceed with something like that.
But even that rule is changed. I mean, it's no longer that the winner of the suit is the winner of the cost as well. I mean, there's recent judgments on that as well. So I think the claimants can be reassured that if you have a potential claim, certainly have the information that is necessary, medical information, maybe death certificates. Would the death certificate say listeriosis is a cause of death?
I don't think the death certificate will specifically state
It'll
the
just say
bacterial
unnatural.
infection. It will say unnatural, but there will definitely be a post-mortem and autopsy report to support that. So in cases where you have a death certificate that states natural causes, it's unlikely that that would be sufficient proof.
Sure.
There must obviously be something more than that.
Yes. With regard to the which courts would you proceed in? I mean, people would want to believe that if it's a massive claim going into millions, for example, obviously it's the High Court. But would you bring such a claim in the regional court, magistrates court?
I think in most cases where people intend proceeding with these claims, you are looking at High Court jurisdiction. In other words, it will be relatively bigger claims. I can't see why anyone would proceed in the regional or lower courts because the potential quantum could be relatively high. And you cannot, once you've issued summons in a lower court, transfer that to a higher court once it becomes apparent that the claim is worth more. So out of principle, we would litigate out of the High Court, and if at later stage it transpires that it is not a big claim, you can then have the option to transfer a matter to regional court.
Yeah.
But really these days, it's up to the plaintiff to decide out of which court they want to proceed with the claim. The effect in the end, of course, is that a High Court might award costs on a lower scale, not on the High Court scale, but I mean, that's not really relevant to determining that.
Okay, time for another and final short break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to the final quarter of Legal Ease, the show that converts legal jargon into legal ease. Tonight, a very significant topic of listeriosis and the kind of compensation you can claim and how you can claim it. Joining me is an expert in this field, Chris Smith. En julle is welkom in Afrikaans ook, julle vra te vra. Chris is tweetalig. Chris, with regard to, Chris, we have a caller. Caller, please go ahead.
Yes. Good evening, Chris.
Good evening.
Yes. Could I like to find out now, say example now you have breakfast at one restaurant, you have lunch at another restaurant, you have supper at another restaurant. In the process you pick up this listeriosis bacteria. How would you then, who do you then sue? Because you wouldn't know where you have picked it up.
That's a very good question. Like we mentioned earlier in the show, the fortunate thing, if you can call it anything fortunate, that this specific strain of bacteria has been identified. So if there is then medical evidence to support that, I think that would answer your question. Also bearing in mind that if you are proceeding in terms of the Consumer Protection Act, you will not necessarily have to institute a claim against the specific restaurant, but maybe list the restaurant as well as their suppliers and the manufacturers. So everybody in the chain can be held liable for the infection once you get past proving it, of course.
Thanks, Chris.
You're welcome.
All right, you're welcome. That's an interesting topic. I mean, unless you had the same meal at 3 different restaurants on the same day, but then you can always go back to the supplier. I mean, not necessarily to the restaurant.
That is correct, because that would be much easier to trace, of course, where the restaurant got the specific product from
Chris,
that you mentioned.
the minister made an announcement initially that you had to get rid of all the chicken. You had to wipe down your fridge with bleach. You then had to tie the stuff up in a place. I mean, it sounded like science fiction, like a bug gone wild. Is it that serious?
Well, someone referred to the listeria, hysteria, and even although it's a bit of a tongue in the cheek, it might bring a smile to someone's face. This is the biggest outbreak of the listeriosis in history, as far as I know. The listeria bacteria being so prominent and causing so many deaths. So at that stage when that was said, there can't be an overkill, if I can use the phrase, in a situation like that. What must be done must be done. And at that stage, I don't think there was really enough research and enough information available to give out to the public, but that was certainly a step from the Department of Health to try and ensure that this doesn't spread any further.
You see, my concern would be for the person that throws the food into the dustbin, okay, albeit in a plastic, but there are people that search through dustbins for food, and they could get contaminated. They don't know what they're eating, and they don't know that they're dying from this thing.
That is correct, sir. And like we mentioned earlier, it is unfortunate that there is a portion of the population that are unaware of the outbreak, and even if they are aware, they don't have the knowledge of how to dispose of these infected products.
Is there a cure for this? I mean, if you contact it, and what can you do?
It is definitely curable. And
Okay.
that is why it is so sad that so many people had to lose their lives, and why so many people are still affected, and I think will still be affected as time goes by. But it is certainly treatable, but it must be
Chris,
diagnosed.
we have a caller. Caller, please go ahead.
Thanks. This is Bert for Chris. I just want to get an understanding. In a matter like this, if you, firstly, you mentioned earlier that you registered this class action. Where does this class action be registered? And let's say, for example, a group in Gauteng wants to lodge the so-called class action. There's a group in KZN that wants to do the same. Do they need to link with each other before they could sort of collaborate together? Because they wouldn't know each other in this instance. That's the first aspect. The second aspect in relation to how the process, is it an application procedure or is it an action procedure that will be brought forth in a matter like this? And does this now mean that the parties in these different categories of so-called class action would now be separated? For example, you have an action in Gauteng because maybe the head office is in Gauteng, and you might have an action, and let's say that the manufacturing plant was based in KZN. So how would you sort of put it all together so that you have this action actually reaching the courts or the prescribed jurisdiction that is basically there. I'll listen over the period. Thank you.
There's an interesting question, definitely pertinent to the situation where we're finding ourselves in. There will be more than one class action, most soon of. And to answer the caller's question as to whether everybody has to join in the same action, certainly not. There will definitely be different people, different groups forming different class actions. It would be ideally suited for people with exactly the same type of claim to join the same action, but not necessarily everybody in one big action. And like I mentioned earlier, there will be certain individuals that will proceed with the claim on their own. The certification thereof might be a bit of a legal jargon because there are no specific laws governing class actions in South Africa. If one considers, or if a group considers proceeding with a claim, it has to be certified by the High Court as being an eligible claim before they will be allowed to proceed with a claim like that.
Yeah, I think the question also was, will you bring a summons or an application? Obviously a summons, because an application you could run into problems with the Plascon-Evans rule.
That's
You're
correct.
seeking final relief. I think the caller might have been legally trained as well. With regard to jurisdiction, surely the safest is for the plaintiff to follow the defendant or the whole cause of action arising. And following the defendant will mean finding out where the registered officers are. So multiple class action suits, multiple plaintiffs, application for registration with the registrar of that particular division, because there is a formal process of registering your name and saying what the claim is, and then following the defendant at its registered offices.
That's correct, Ashraf. Jurisdiction is something that you will still have to comply with, and you will still have to show that the courts that you're approaching has the necessary jurisdiction. But having multiple defendants in this case might make it easier to sue out of a court that is more suitable for the plaintiff.
Yes. Well, unfortunately, we've run out of time. Chris, thank you very much for joining us here tonight.
You're welcome, Ashraf. Thank you for having me.
Really interesting. And you, the viewers, thank you for joining us with your valuable contributions and questions. You make the show alive for us. And if you need to get in touch with Chris, what are your details?
You can contact us by sending us an email at info@dsclaw.co.za, or you can have a look on our Facebook page. You can just have a search under DSC Law, DSC Attorneys, or you can email us on I mentioned info at...
Yes.
Yes, or you can go onto our website. Our website, yes.
Okay, thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh.